afternoon.
Oh, good afternoon. Just by way of initial note, my lord asked yesterday about whether or not there were protocols to the VCDR, and the answer to that is there are 2 protocols. They're both of them optional.
Since it was...
No, they were both signed up to on the same day as the treaty itself, the VCDR itself. And the purpose of them, it's quite a common technique, the purpose of them is to leave, as it were, the slightly more controversial bits in a protocol, which states can then sign up to or not as they see fit.
Yes.
So there are only 2 of those, but we're not aware of any other protocols, or certainly not any amending protocols.
So no amendments, but 2 protocols.
But 2 protocols signed up to on the same day, the 18th of April 1961. I was going to turn to the question whether the operation of the immunity provisions of the VCDR, and indeed the other provisions that bear on these issues, lead to incompatibility with Article 3 ECHR. And I wanted to start very briefly just by summarising where we are on the nature of the obligations under Article 3. I'll take this very quickly because it'll be well known to the court, and I'm not sure there's much controversy about it. The terms of Article 3 are well known. The basic taxonomy of Article 3 is also well known. There are, as I indicated yesterday, express negative obligations on the state not to commit itself Article 3 ill treatment. We're not dealing with that aspect. There are then positive obligations on the state that have been implied or discovered within the article, and those are essentially designed to protect private individuals from Article 3 ill treatment at the hands of other private individuals. So the state's obligation is in effect an interventionist one. The key distinction, of course, between the negative and the positive is that under the former, the obligation is absolute. There are no circumstances in which it's acceptable for a state itself to torture or Article 3 ill-treat. Under the latter, it is not. It is, in essence, an obligation conditioned, and I'll come precisely to the wording that's been used on the condition, but conditioned by, for the sake of shorthand, reasonableness. Or, to use Mr. Webster's phrase, inherently limited, that implicit obligation, that positive obligation. So far as the nature of the positive obligation is concerned on the state, again, that's been the subject of very extensive case law over the years, not least because precisely the same suite of positive obligations exists under Article 2, right to life, and Article 4, which is frequently the article relied upon in the context of allegations that someone has been trafficked or is a victim of modern slavery. But the same sort of positive obligations, and there are in essence, I'm sure the taxonomy could be made more complicated than this, but there are in essence 2 types of positive obligation on the state. The first of them is structural/legal framework, and the second of them is the operational duty, or what's sometimes called the Osman duty. And that is, of course, a protective and proactive obligation, or an obligation to take proactive operational steps. The police step in to throw a screen around an individual particularly at risk. In some circumstances, dealt with extensively in the case law, to protect against a real and immediate risk, is the way it's normally put, of ill treatment. All are now agreed, in this case, for the purpose of this appeal, that the structural/legal framework obligation is not an absolute obligation, and that in principle there can be no distinction, at least so far as the basic principle underpinning is concerned, and in terms of the nature of the qualification, between on the one hand the structural obligation and on the other hand the operational obligation. And that's for the obvious reason.
I hesitate to rise, but I just don't want my learned friend to proceed on a misapprehension. That's not a position which is accepted by either the local authority or the appellant. We do not consider the qualification to the operational duty in relation to individualised decision-making to be equivalent to qualifications on the systems duty. I just don't want him to fall into error, because we will deal with it in reply. That's not a point which I or Miss Markham accept.
But you're arguing the systems duty in this appeal.
We're arguing the systems duty, that's right.
And so the question to which that gives rise, I'm sure that's a helpful intervention, the question to which that gives rise is why it should be, if this is going to be the submission, why it should be that the obligation in relation to the systems duty should in effect be conditioned less heavily, or the obligation on the state should be more onerous than it would be in the context of an operational duty, which only arises in circumstances in which there is an identified real and immediate risk to a particular individual or set of individuals. But in any event, the point...
We all agreed that the qualification was, so far as reasonably practicable.
My Lord, I thought we had, and we're slightly back into the territory I thought was being denied, as it were, which is whether there is some...
Apparently we have, where systems duties are concerned, and since the appeal doesn't concern operational duties, we're all agreed.
Well, as long as we're all agreed that there is conditioning on the systems duties.
Somebody's got to tell me that we're not.
Yeah.
And why not?
We do agree in relation to that. It may be a misunderstanding about the point that was made. Myself and Miss Markham do not accept that the nature of the qualification on the systems duty is equivalent to the nature of the qualification in respect to the operational duty. We accept the qualification in relation to the systems duty of reasonably practicable. That's common ground between all of us.
That's academic then, because we're not. The appeal doesn't concern the operational duty.
My Lord, well, if that's so, so be it. And
you didn't say equivalent. You said in principle no distinction.
I did, and if you wanted a reference that demonstrates that those sorts of qualifications apply to any positive obligation, and I take that phraseology deliberately, you have it in Madzhonov and Russia, paragraph 174, tab 36, page 901, where the court in Strasbourg said it is a well-established position of the court that the scope of, quote, any positive obligation must be interpreted in a way that does not impose an impossible or disproportionate burden on the authorities. And if you wanted authority to the same effect, you have it again in Smiljanic and Croatia, which we've cited at skeleton paragraph 17.5. You have it in the raw in the new authorities, tab 65, and the relevant paragraph for present purposes is paragraph 70, which makes the same...
You've gone too fast for me to get all those references.
Well, I'm sorry, Smiljanic is the second one.
Smiljanic is very easy to spell, presumably, but
it is
Croatia. Where is it?
It's in tab 65 of the authorities.
Where's the page?
I'm not sure those ones were paginated, I'm afraid. It was our second loss. I don't think it's been paginated, I'm afraid. It's tab 65 if you have it.
It's not the second bundle.
It's not the second supplemental.
No. It's
What's the para number?
70, my lord.
65 actually.
It's tab 65.
It's tab 65.
Para 70.
It's para 70. And if you're going on the law report page numbering, it's 315.
It's 70. Did you say?
Might be 234 of the PDF, I'm being told.
It is 234. Yep.
Does that take you to paragraph 70 at the top of the page?
Yep.
So that's paragraph 70 of Smiljanic. And I don't want to take up time on this, but if one casts back from paragraph 70 to the previous paragraph, starting at paragraph 64, you will see that what they're actually talking about between 64 and 69 is the systemic duty, is what I call the structural or legal framework duty. So what is said in paragraph 70 applies to the structural framework duty, so it's to exactly the same effect as the statement made in Madzhonov and Russia. And we've also given you a reference to the FI case domestically, tab 6, page 212, paragraphs 41 and then 61, making the same point. I said I was going to come briefly to the language that's been used to provide the conditioning. We've been using reasonably practicable as a shorthand, but what is actually said in the context of all of these cases in relation to the conditioning of the positive obligation, be it systemic or operational, are three things of note. The first thing is the reasonableness concept. So Baroness Hale in E and the RUC, tab 2, paragraph 40, sorry, page 40, E and the RUC, tab 2, page 40, paragraph 10, don't invite you to turn it up. What is reasonable in all the circumstances, mirrored in E and the UK, in Strasbourg, paragraph 92, tab 22, page 1088, a duty to adopt, quote, reasonably available measures. So the first language is reasonableness, to which you can add practicability if you wish. The second bit of language you saw from the cases we've just looked at, which is that the state is concerned not to impose what they've described consistently as an impossible or disproportionate burden on the state through the imposition of this positive obligation. So you've got impossibility and proportionality built in through that phraseology. And the other thing one takes from the starting point of all of this jurisprudence, which was the Strasbourg court in Osman.
What's the authority for the impossible or disproportionate burden? Because that might be important for your argument.
Well, my lord, it starts in Osman 116, but I think that was the language used in the case we just looked at.
Smilianich.
Yeah, yeah, but it's just repeating language,
Which was it?
I think it was Smilianich at paragraph 70.
Croatia at 70.
Yeah, Croatia at 70. But it comes from Osman. It's a mantra. Mm-hmm. The start of it is Osman 116. And that's...
I mean, it's important because, isn't it? Because if you're right, not imposing an impossible burden...
Or disproportionate.
Well, I mean, you don't even need disproportionate. It is virtually impossible for you to throw open the whole of the diplomatic regime, or if not impossible, certainly disproportionate.
Exactly. That's why we alert
what you say. I mean, you say that is a fate beyond, you know, would be a terrible thing to happen.
My lord, I do say that. The other reason it's significant that language is used, at least in part, is because it takes you very close, if not exactly to the point, of those limitations inherent in Article 6 and access to court, which is a subject of repeated consideration in the Strasbourg case law, where the restrictions on access to court have to be proportionate.
What paragraph in Osman were you relying on?
It was 116, my lord. Okay. That's the absolute standard paragraph, which is always wheeled out in all the cases ever after dealing with operational duties.
So,
can I just give you the third?
Yes.
Yes, I'm sorry. The third one. That's what you were about to ask. The third one you also have, if my Lord Lord Justice Baker has Osman 116 to hand, within the scope of their powers. Now, obviously, that's more relevant domestically because you can't require the police to go and do something that they can't do as a matter of domestic law. But it imports, perhaps unsurprisingly, yet another concept that one normally finds in the qualification to the articles of the convention that have a paragraph 2, or where you're dealing with implied limitations of the kind that you had in relation to access to court under Article 6.
It's not relevant here, really.
Well, it's not relevant here, save for the fact that within the scope of their powers, at least provides that recognition that one of the constraints, one of the limits on what the state will be required positively to do is lawfulness, is legality. And that must encompass, we submit, both domestic legality and international legality. And now you see the relevance. So to summarise, and I'm going to go back to the shorthand so I don't have to keep doing it, but it's important to bear in mind that we've got reasonableness, proportionality / impossibility, and within the powers, and legality, all built in inherently to limit this implied positive obligation within Article 3.
So you don't mind calling it reasonable practicability, but it is a shorthand.
Exactly so, as long as one understands that built into that is all of that stuff.
Okay.
So that's that. I wanted to pick up very briefly on a point which my learned friend Mr. Webster made yesterday about Article 6 and the essence of the right. Lord Justice Moylan will recall the debate you had with Mr. Webster yesterday about that. Why is it, how can it be said in Al-Adzani that mantra, which is always wheeled out in relation to Article 6 and restrictions on access to court, so it doesn't impair the essence of the right, that language, how can that work in circumstances in which the effect of the immunity in question was actually to prevent someone from getting into court? That was the very function of the immunity. And the answer that Mr. Webster, the only answer he felt able to give after solving his own puzzlement, was that that could only be explicable because the implied restriction within Article 6 indicated that the right itself was, as he put it, inherently limited. The more prosaic, but perhaps less forgiving interpretation of it is that they did what they normally do in Strasbourg, which is to have a paragraph which contains very well-trodden general principles expressed almost as mantra, and then came to apply them to the individual circumstances without necessarily breaking down all of the elements. But the fact of the matter is, in Al-Adzani, they plainly, the one thing that can be said with absolute confidence, is they plainly did not regard it as impairing the essence of the right in that case, even though the consequence was that the individual could not get into court. The more principled answer is that even if my learned friend Mr. Webster is right, and it's because the Strasbourg court recognised that that Article 6 thing was inherently limited, we now see that so too is the positive obligation under Article 3 in almost exactly the same way and by reference to almost exactly the same concepts of legality, proportionality and reasonableness. That's all I wanted to say about the nature and structure of Article 3, and I wanted then to conclude by making 7 short submissions, if I may, on the direct question I posed at the outset this afternoon, which is there an incompatibility flowing from the provisions and the immunities and privileges conferred by the VCDR? And some of these I can take very quickly because we've covered the stuff of them yesterday. The first submission and the starting point is that there needs to be a clear acknowledgement that on its proper interpretation, applying the principled approach set out in Res, and every one of its notes of caution in the speech in the judgment of Lord Sumption, the VCDR does operate to provide immunity here. There are, as I indicated yesterday, clear and well understood provisions, express exceptions. None of them is applicable here. It is perhaps of interest to note that below an attempt was made to interpret the VCDR by reference to the UNCRC. The argument was that the application of the immunities in Article 31 were extinguished in effect in the context of care proceedings because the obligations under the UNCRC took priority over that article in the VCDR by operation of the lex posterior rule in Article 30 of the Convention on the Law of Treaties. That is an untenable argument and has now been abandoned. But it's maybe important to be clear about why, because there is no undermining of the VCDR and its clarity by the UNCRC. There's nothing ambiguous about the VCDR. Its rules are clear. So are the considered exceptions, and so is the importance of giving effect to the natural meaning as a matter of international law. And the other thing to note about the UNCRC is that it contains a number of more or less general and more or less aspirational provisions. What it does not contain, expressly or implicitly, is the shred of a suggestion that it was intended to amend or override or affect in any other way the customary international law rules codified in the VCDR. And it would be little short of amazing if that had been the intent, but it wasn't said so. It didn't say so. That's the first point. Secondly, it is necessary we submit in this debate about the limits of the Article 3 positive obligation to acknowledge the thoroughgoing importance of the VCDR structure and those clear, well understood rules that it sets out. And each of the points I made yesterday at the outset about the nature and effect of the VCDR are pertinent at the stage of incompatibility. In particular, as you are aware, the self-contained body of rules, long established, its own structure and system of remedies.
Well, there's 8 points which you gave us yesterday and we wrote down.
Yeah, those are.
So you can make them again forensically, but that would be to assume that we didn't listen to your submissions yesterday.
I'm not going to do that.
Wrongly.
But you have all of those points.
Yes.
And the only other reference I wanted to give you was to Lord Dyson's judgment in paragraph 44 of the Estrada case, behind tab 63.
Estrada.
Estrada.
At page.
And again, I'm afraid it's 63, so it's in the supplemental bundle you were looking at earlier. PDF reference. Page 188 in the PDF.
Yeah, 16. Well, it's 167. It starts.
167 it starts, and I want paragraph 44 if you've got it.
Which you say is 188.
I'm told it's 188. You'll see how he puts it there. On the contrary, the clear and consistent position taken by the courts is that for a claim to immunity to be regarded as a proportionate restriction on the right of access under Article 6, it's necessary to do no more than determine whether the grant of immunity reflects generally recognised rules of public international law. And I'll come back to that point when I take you to Al-Adzani, which I'm going to do very shortly, because that we respectfully submit exactly chimes with the reasoning of the Strasbourg court in Al-Adzani, which said that those immunities set out in the context of state immunity there, but it must be a fortiori in relation to the VCDR, establish proportionality, quote, in principle. It's the same point that's being made by Lord Dyson.
His citation from Reyes
Was the Court of Appeal.
Yeah, that's him.
Yeah.
Yep.
And we know that there was a difference of view about bits up in the Supreme Court when it got there. But not about that bit, not about the bit that I've just read out, the beginning bit of 44, which is directly reflective of Al-Adzani. That's the second submission. I'm not going to go back over the submissions I made yesterday about the nature of the VCDR. I can take the third and the fourth points together, if I may, and then develop them briefly. The third point is that there is no European Court of Human Rights case that goes anywhere near the proposition that Article 3 should be or can be interpreted, harmoniously or otherwise, so as to require contracting states to breach the VCDR by overriding the immunities accorded to diplomats. On the contrary. That's the third submission. And the fourth submission is that in any event, as a matter of domestic law, under the constitutional arrangements set up by the Human Rights Act, the hurdle for a domestic court to get to that place is very high indeed. It would have to be demonstrated to this domestic court that the European Court would go there, and to do so with a requisite degree of clarity. And that is for good constitutional reason.
But this is AB.
It is.
59.
I was going to develop that fourth one first because it's the shorter one. It may be as well to have AB to hand.
Well, that's
it's tab
AB.
15,
Yeah.
page 742.
Yeah. I mean, speaking for myself, and I guess for my colleagues, did you say 742?
It's 742 it starts. You'll be very well aware of the context. Young offenders, Article 3. When could they be locked up in solitary and all of that.
767.
767 is the key page.
Well, I think it's important to read the whole of really paragraphs 50 to 60.
My lord, that's what I was going to suggest. You've probably read them already.
I have.
I was going to pick up a couple of points, if I may. But you will see when you go back through those paragraphs, if you haven't already done so, that where they ultimately lead, in the first instance at least, is to the test that is set out in paragraph 57. But the earlier paragraphs that precede paragraph 57 are essentially analysing the constitutional underpinning.
Yes.
Why is it that they get to the test in 57 and then 59 to 60? And the answer to that...
It's a little bit difficult, isn't it? Because they could be said, I mean to a black letter commercial lawyer like me, it could be said that this is slightly airy-fairy, because it says on the one hand, of course we can't go anywhere, no further than the European Court. And then it says, but of course you can, if you're fully confident that the European Court will go somewhere, you can go there. How you become fully confident is left to the imagination of the reader.
Well, it is and it isn't, if I may respectfully say so, for reasons I will develop.
Yeah.
I mean, you're not left entirely with an open plane in relation to that. And in part, the significance of reading the earlier paragraphs of this judgment are because the constitutional underpinnings for the rules that then come in 57 and 59 to 60, if they're comparative, which they're not, but I'll come to that in due course as well, those constitutional rules and those constitutional underpinnings assist you in determining where the limits actually are.
But of course you have to feed in cases like Rayburn, on which Miss Gallagher relies, where the courts have been, what should we say, more willing than one might think if you read 50 to 60. I mean, they cite Rayburn.
They do cite Rayburn, and there's no inconsistency between this approach and Rayburn. It's just a question of the degree to which you are inviting the domestic courts, in effect, to take a step which would be controversial even in Strasbourg, if one wants to put it at its very loosest. But can I do it in stages? The constitutional underpinnings are clear. They get to the test they do in 57, which I'll come back to in 1 second, deliberately as a high test for the domestic court to surmount. Because of two things. Firstly, because they recognise, as is evident from this judgment and indeed lots of other recent judgments from the Supreme Court, they recognise that there will be some issues. Let's not get too hung up about principle versus fact. It could be a combination of the two, but there will be some issues which are much better dealt with by the international court. So it's, if you will, domestic institutional competence versus international courts institutional competence. And the paradigm example of that would be something which, if the principle was to be established or if the position was to be reached, would affect all contracting states on its logic. That is something which naturally an international court would be much better placed to decide upon than a domestic court. That's one strand. The second strand is a purely domestic one, which is that the Human Rights Act provides, if you will, the legislative exception to dualism. Otherwise, the ECHR would sit on the international plane and would attract the J.H. Rayner principle. What the Human Rights Act does is to bring that international law by scheduling it, a bit like the Diplomatic Privileges Act 1964, it brings those rights into domestic law in that way. But what that means is that Parliament has given the courts permission, if you will, to apply as domestic legal rights and obligations the scheduled rights and obligations to the HRA, but has only given that permission. And given that the system of rights and obligations is capable of developing, for example, under the Living Tree doctrine, in Strasbourg, it's a changing thing. It isn't a set thing. And so there needs to be a degree of confidence in the domestic courts before taking the jump, because the risk otherwise is that they will step outside the boundaries of the legislative permission provided by the HRA. Much more prosaically is the point that attracted Lord Brown all those years ago in Ouseley, that is referred to in paragraph 56 of AB, which is that if a claimant wins domestically, then that sets the principle in stone as a matter of domestic law, and the government can't go off to Strasbourg.
Government can't appeal.
Exactly so. But that's, as it were, an aspect of the deeper lying water.
Well, it's the same thing. I mean, if you
But
step
it's the legislative
outside the
permission.
line, then you're an outlier, and you don't want to be an outlier because the living tree is to be
Determined by Strasbourg.
growing in Strasbourg.
Yeah. Unless it's, yes. And so, my lord, that we respectfully submit is why they get to the position that they do in paragraph 57. We've all started and jumped to 59 to 60, but the key bit is in 57.
Yeah. Yeah. It's the fully confident, fully confident.
It's the fully confident squared, exactly so. They're obviously setting it down as the test, because that is so. I just wanted to give you one other reference. You can have that hard copy if you wish. In the X in the passports case, which was called Appellant, again a similar looking composition of the Supreme Court.
Sorry, which case is that?
This was called Appellant. It was a case about whether or not non-binary people were allowed to be able to say we want X in the passport.
Yeah, how do you spell it?
Let me hand you up a copy of the
I don't really want a copy because I can get it on the screen if you tell me how I spell it.
ELAN.
I don't believe we have it either.
No, ELAN hyphen CANE. As Secretary of State for the Home Department, 2022, 2 weeklies, 133, and the paragraph you want.
Have we got the neutral citation number?
2021 UKSC 56.
Thank you.
And the critical paragraph is 63, where they cite and apply.
53.
63,
Thank you.
63, they cite and apply AB.
Right.
Effectively saying they can't go further than they can be confident the European Court would go, CAB paragraph 57. So that's the test, the fully confident squared test. And then one comes to 59.
So you don't want us to go to Elan.
It's just that one paragraph. It's
just 63 citing 59 and then 57. You'll see the nature of the analysis. It goes a bit to the point my Lord the Master of the Rolls was putting to me yesterday. I feel a bit nervous, said the Master of the Rolls, about balancing these difficult things. Well, this is one way in which that is, as it were, you're constitutionally assisted. But what the
It summarises the AB principle in 2 sentences, doesn't it?
It does, in a nutshell.
And it doesn't use the term fully confident anymore, but any confident.
It does, to the extent that that matters. Having done it twice in paragraph 57, I don't care which.
It's like wrong and plainly wrong.
Yeah. Can I come to 59 and 60 and how they work together in AB, if you just go back to them?
Yeah.
Can I be absolutely clear what we are not saying and have never said, and that the Supreme Court has never said, apart perhaps from some implication in the judgment of Lord Kerr, indeed, that you were taken to yesterday? We are not saying that you need, in order to be confident or fully confident, a Strasbourg case bang on the point, legally and factually, before the English court can apply the convention. But likewise, it is not open if one is being faithful to the constitutional underpinnings that I identified earlier, and being faithful to the paragraph 56 point as an aspect of the HRA point. Likewise, the court in England cannot simply extrapolate just because there is the basic principled framework under an article in Strasbourg. So, for example, it isn't open to the domestic court here to say, or wouldn't be open, we submit, to say, well, we've now reached a stage where under the Strasbourg jurisprudence we can see that the basic taxonomy under Article 3 is, as I described it earlier, operational duty, systems duty, negative duty, positive duty, blah, 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 blah. Once we've got to that place, with the basic rudiments, the basic scaffolding in place, it's fair game thereafter for anything under Article 3 because that basic rudimentary framework is in place. That likewise is not the way it works. What instead is being done in AB is to set the test of fully confident and then to see how that works and explain how it works in 59 in particular and then 60. And what is truly being done is to introduce as a mechanism, perhaps the critical mechanism to guide you as to whether or not you're stepping too far out onto the plane, a concept which is very, very well known to the courts in this country when they come to consider whether they're prepared to develop the common law, namely incremental development. And very often when the court is invited to develop the common law, it's looking at precisely the same sort of boundary. It is saying, can we do this incrementally, as an incremental development of the previous state of the common law, or is this something where Parliament has to step in and exercise its authority to give it democratic legitimacy and all the rest of it?
Normally, Sir James.
Normally. Well, that seems to be the idea.
See convoy collateral.
Yes, but that, yes, quite. But you see the idea being introduced if you look at paragraph 59 at the top of page 768.
Yeah.
The application of the convention by our domestic courts in such circumstances. So in such circumstances, when can you develop? You can develop, there is a limit to it. What's the limit? Will be based on principles established by the European Court, even if some incremental development may be involved. So it's a question of degree, it's a question of how big the step is. And the step can be a principled step, it can be a combination of application of old principled framework to very controversial new circumstances. It doesn't matter. It's about the scale of the step. Mm-hmm. And you see where this submission goes. Here we submit, sorry, I should just finish before I get to where we are here. Just look at paragraph 60 in that light. The note of caution we would urge in relation to paragraph 60 is that it describes why that particular case fell outside that incremental approach and outside the fully confident phraseology or rubric. It does not purport to establish that those are the only circumstances in which a court should apply the constitutional boundary. That's the lifting that's been done in the previous paragraph in 59. So 60 is about why it falls outside. It isn't an attempt to define the boundary posts. In any event.
You've got to read the thing as a whole.
You have. You
know, you can overanalyze this judgment. Even this judgment you can overanalyze. But it's pretty clear what it's saying.
It is. And my lord, I hope that I've at least sought to assist you on your question, which is, are we just in the dark on the sort of test we should apply? How should we do it? My short submission is, it's about the size of the step.
The incremental.
Exactly.
Very helpful. Yes.
So here, and again, test all of these points by reference to the twin underpinnings of this, in principle, institutional competence of domestic versus international courts and permission under the HRA. The logic of my learned friend's position would affect all contracting states because they're all signed up to the VCDR and they're all signed up to the ECHR. It would place, on their argument, the UK, brackets and all other contracting states, in breach of one convention or the other. It's a true Scylla and Charybdis legally. 3, it's a very big step indeed to say override the VCDR or frame exceptions which haven't been agreed by the parties to it. That's a very big step. This is not just applying very well established principles to a particular and relatively easily predictable fact pattern. We're not in that turf at all. So for all of those reasons, we respectfully submit that we are squarely within whatever conception you have, without overanalyzing it, of AB. That's AB.
So is your submission that we can't decide what the European Court would be likely to do in this situation? Because I thought your submission yesterday was to...
My Lord, that isn't my submission. It's a question of which order you put them in.
Right.
That's in part the reason for showing you Elan Kane, because what they did in Elan Kane is what we invite you to do here, and to some extent what the divisional court no doubt would have, or might have felt comforted in doing, had AB been promulgated other than 3 months after they promulgated their judgment. But in Elan Kane what they did was to say, we look at the arguments under Article 8 on their merits. We see that there are serious Article 8 issues involved. We see that there are issues that affect intimate private life. Nevertheless, analysing Article 8 justification, we find it justified to have M&F only in the passport. By the way, final paragraph of the discussion or the analysis, fully confident we can't be. So that's the way I invite you to do it. And one can see that logically, you might say, well, you've got to cross the threshold of arguability, and if you can't do that, stop at the pass and don't go further. But that's not the way it's traditionally been done. And in part for good reason, because no doubt if this case goes further, it's capable of going further, and the logic of AB is that it's capable of going further to Strasbourg. And so there is at least something of a burden on the domestic courts to seek to provide what assistance they can. Does that answer that priority question, as it were? I was going to turn to the European Court case law, so the third submission was to develop that a bit. And my submission is that the principled approach that you see from the Strasbourg cases, entirely unsurprisingly, allows the state to give effect to long-established immunity that forms part of customary international law and or treaty obligations, recognising its status and also all the broader benefits and the vital aim which is being pursued in particular by the VCDR. And the European Court of Human Rights has specifically and long accepted that, quote, generally recognised rules of public international law on state immunity are to be recognised under this principle as a critical, perhaps the critical part of the international law context to which reference is made in Article 31(3)(c) of the VCLT. And I wanted to go first, if I may, and principally, to Al-Adzani. That is in the authorities, and I've got 2093.
I don't think it's there.
Right. Tab 21.
Al-Adzani, tab 21.
Tab 21, page 1036. Thank you. I'm sorry, I've lost it for a moment. You see the basic context from the head note at 1036. And the key bits, so far as we are concerned, are at paragraph 54.
I mean, it was a very clear case, wasn't it? It was a question of whether the English courts could be used by a Kuwaiti to bring proceedings in respect of torture which had taken place in Kuwait, wasn't it? That's what it's about.
What?
Yeah.
It was.
And the court said no.
Court said no.
Yeah.
But if I could just...
Despite the fact it was torture.
Exactly so. And despite the fact that torture
is a jus cogens.
Is jus cogens, at least in part. Again, one needs to be a bit careful with that, on the basis that the UN Convention against torture contains quite a number of obligations, some of which are and some which aren't jus cogens, some which are and some which aren't.
But in this case it was suing the state, and the state had done the torture, so...
You were close to that.
You were close
that
to
was
that.
That was the balance. My lord is right.
Yes.
Can I just invite you to remind yourselves of paragraphs 54, 55 and 56 initially for the principled approach.
Yeah.
And so you see from those paragraphs, and the first point perhaps to make is that the position as between state immunity on the one hand and VCDR on the other is either indistinguishable or a fortiori in favour of VCDR. If that
Well, I
makes
didn't
sense.
quite understand the submission that I think was made, either orally or in writing, on the other side, that your cases are state immunity cases which can't be of any relevance. Is that what's said against you?
I'm not sure it goes quite that far in fairness to my learned friend, but I mean there is
State immunity is
You can't sue the
domestic
state.
legislation.
is
Domestic legislation.
yes, state immunity.
Act.
Yeah.
Yeah.
And there are conventions and customary international law rules in relation to that. But you'll see the basis for it analysed in paragraph 54 of this judgment.
Yeah.
But my submission is there can't be any relevant distinction for present purposes between that and the rules that protect international relations under the VCDR. But you see how the court then analysed it, assuming that they're effectively we're dealing with the same species of thing or better from our perspective in the VCDR. And you see the way in which they deal with it. Last sentence of paragraph 55, the convention should, so far as possible, be interpreted in harmony. That's the 31(3)(c point. And what they actually do is to say, so we stick with those rules of CIL. And those are in principle proportionate. And that's perhaps the key point to bear in mind, because that was the point that was reflected in paragraph 44 of Lord Dyson and Estrada. Do you recall? That's the chime back into paragraph 56. It follows that measures taken by a high contracting party, which reflect generally recognised rules of PIL on state immunity, cannot in principle be regarded as imposing a disproportionate burden. So that's where you get to. If you can establish that it's a rule of CIL, as state immunity was, as the VCDR rules are, then that is in principle not disproportionate, or putting it positively, that is in principle proportionate.
That's assessing. It's assessing justification
That's assessing the justification, that's assessing...
for the approach taken by the state.
Yes.
So in this case, when it's submitted that the issue was framed from the wrong perspective, and it's argued, I think it's paragraph 36 of the submissions, that it can't be reasonable to require a member state to adopt a system which requires them to violate Article 3. If you put it the other way around, looking at this, is the state's decision to have in place a system in respect of children of diplomats that effectively, and this is putting it too simply, complies with the VCDR, so excludes them from the protective system in place for other children who are in this jurisdiction. That is
In principle reasonable.
in principle
Justified,
or
proportionate, reasonable, whichever one you want to do.
And you say the proposition is just as valid if one reads diplomatic immunity for state immunity.
I do.
And Article 3 for Article 6.
Exactly so, because we're dealing with, that's why it was important to emphasise which bit of Article 3 we're dealing with. We're dealing with the one that has built into it reasonableness, proportionality, impossibility, and so on. So we're dealing with that parallel. And in answer to the first bit of your question, yes, we do say that if state immunity is PIL and attracts all these principles, a fortiori, for all the reasons I went through yesterday, the VCDR.
And you say that the factors which led to the proposition in the first sentence in 56 also apply mutatis mutandis.
I do.
In the circumstances.
I do. Of course,
diplomatic.
It's not exactly the same, but that in some ways is the significance of Estrada, because Estrada does apply exactly the same approach, see, for example, paragraph 44 of Lord Dyson, into the diplomatic sphere, and quite right too, because there couldn't be any sensible distinction between the two.
Well, I think Ms. Cowherd says there is a distinction.
Which is the one is state immunity and the other one is VCDR.
Yeah.
But that can't work because the significance of this is that these are generally accepted rules of international law, which have reached the stage of customary international law. And in relation to VCDR, that's absolutely clear. There's no dispute but that. CIL beforehand contained similar rules protecting the inviolability of person, the inviolability of premises, civil jurisdiction immunity. I mean, we're back into all the bits I went through yesterday, but it's CIL. It's right.
You say this is CIL and says that, and therefore there's no.
I do. But you see how the argument develops. I mean, in some ways that's the easy bit, as long as one has got the punchline right under 56, which Lord Dyson, I respectfully submit, did, in the context of diplomatic immunity in Estrada. You see the way the argument develops, though, which is of some real interest here, because if you look onto 57, you've got a very strong echo of what happened here. This is going effectively to my precision point of yesterday. Remember I made the point at the end of yesterday that said you need to be precise about what it is you're saying is a rule of CIL or is a rule of jus cogens. And you see what is said at the end of 57, at the top of page 1053. The applicant asserts, however, that his claim related to torture and contends that the prohibition on torture has acquired a status of jus cogens norm in international law, taking precedence. That's the international legal significance of it being characterised as jus cogens, taking precedence over the treaty law and other rules of international law, subject to the procedural points I made yesterday under the VCTL. That's the same sort of thing that we've got drifting around in the arguments here. But you can see why it was put that way. He says, well, that's all jolly interesting. It might normally work that way, but what we're dealing with here is a claim for torture. And what they do with that, you see from paragraph 61, well, the court accepts on the basis of these authorities, including Pinochet and all the rest of it, the Furad-Zija case, well, the court accepts on the basis of these authorities that the prohibition of torture has achieved the status of a peremptory norm, that's jus cogens, in international law. It observes that the present case concerns not, as those decisions did, the criminal liability of an individual for the alleged acts of torture, and here's the precision, but the immunity of a state in a civil suit for damages in respect of acts of torture within the territory of that state. Notwithstanding the special character of the prohibition of torture in international law, the court is unable to discern in the international instruments, judicial authorities, or other materials before it any firm basis for concluding that as a matter of international law, a state no longer enjoys immunity from civil suit in the courts of another state where acts of torture are alleged. In particular, the court observes that none of the primary international instruments referred to relates to civil proceeding or to state immunity. So what was needed, in a nutshell, see the 61 analysis, was precision. If you were going to say it's frightfully important that it's torture, you've got to be very clear what you're dealing with. What you're not dealing with is, or even there, what you were dealing with was torture by the state, as it were. But even in the context of torture by the state, the precision that was needed was, have you got a thing of jus cogens character or a thing of CIL character that is specifically related to the idea of cutting out state immunity, in that case, VCDR in our case. And
well, the distinction there is between an individual. So if putatively this had been a claim brought against the torturer, they might not have said what they said in 61.
Well, my lord, you may be right to speculate in that way or you may not. It doesn't really matter for my purposes, because my submission is that what you can see here is them analysing the character of the actual thing that they were being asked to do, the character of the actual proposition. And the actual proposition was, please override the immunity on this basis, because the underlying conduct is so serious. And you see the same point being made towards the latter part of paragraph 63. And again in 66.
Now, Al-Adzan is quite an old case, 20 years old. But my researches lead me to believe that it just gets rolled out again and again.
It does.
Is that right?
It is. And I'm going to give you some of them in
You named some of them in paragraph 64 of your.
We do some of them.
Which
And
we asked for. They weren't in the bundle.
you did.
The Lord
I'm
asked
sorry.
for.
Everyone's been trying to keep within the limits of the practice direction, so apologies that you had to ask for those. I'm going to take you to some of the cases Mr. Webster referred you to as well. Just before leaving this, I referred yesterday to the Appellant-Bratzer opinion, the concurring opinion. Can I just take you there briefly? It starts at page 1057.
We did our homework.
I'm grateful. Well then, can I just invite you to, well can I see?
Can you check?
Can I see without being cheeky whether we've sidelined the same bits? The bit that I had sidelined, if I can put it as uncontentiously as possible, were paragraphs 0, capital Roman 2, 8, and 0, capital Roman 2, 9.
Hang on. Oh, I see. Capital Roman 2, 8, and 9.
Or 118 if you want, and then 119. And the reason for highlighting those paragraphs is because what they do in 118, if I can call it that, in particular, is to test, in effect, the applicant's case by reference to the logical consequences if it is right.
Mm-hmm.
So in this case, you'll see what's being done. They say, well, if we were to override state immunity for this purpose, logically that would lead to the state in which you'd have to hold that the prohibition of torture must also prevail over immunity of a foreign state's public property, such as bank accounts. And you could then execute against the foreign state's property in the United Kingdom. So you're testing the logic to see how far the logic goes and seeing whether that takes you into a place of dissonance with other high important
Well, they basically say it takes you down an impossible road.
Yes, exactly so. It's test the logic, and that's of obvious significance, as I will come to. It's also got quite a good, I'm sure they didn't mean it as a soundbite, but the penultimate sentence of 118, international cooperation, including cooperation with a view to eradicating the vice of torture, presupposes the continuing existence of certain elements of a basic framework for the conduct of international relations. So even something as serious and something as viceful as torture nevertheless required that framework to be maintained, is the point being made. So that was Al-Adzani. So it's in principle proportionality, para 56. It's test the logic from Bratzer and Palin-Parr, and it's need to maintain that framework even in the face of something as
I rather like Sir Robert Jennings' quote at the end about the tendency of particular tribunals to regard themselves as different, as separate little empires, which must be, as far as possible, be augmented.
Right.
Yes. Well.
Well, that's perhaps
I don't expect you to comment.
That's perhaps,
The Lord and I go back to Sir Robert Jennings a long time ago.
yeah. I think he was legal advisor to the Foreign Office at one point.
Yes.
Yeah. Anyway, I'm not going to comment on that particular sentence, which may or may not chime. Can I give you one other reference?
It is, as you rightly said, a very good, readable piece of work.
It is.
Yeah.
Unsurprisingly. My Lord, I wanted to give you one other reference, if I may, and I'm just going to give you the paragraph number.
Mm-hmm.
Moylan.
This is another case, or is it person?
It's another case, and it's tab 23, page 1128, and it's paragraph 81.
I didn't get the page up.
It's page 1128, paragraph 81 of Manolescu. I wanted to turn briefly then to the cases which my learned friend Mr. Webster relied upon.
Yes.
He referred the court to 5 cases which he said supported the proposition that the European court would be willing, or you could be fully confident, the European Court would be willing to require a VCDR breach, or would be willing to say that the Article 3 obligation encompassed a requirement to breach the VCDR. And he did so on the basis that the cases, it was said, showed that the European Court of Human Rights might be willing to allow a violation of an, I underlined an international agreement, in order to guarantee compliance with the Convention right. And I should emphasise at the outset, the Secretary of State's case has never been that a requirement to comply with any old international agreement would necessarily trump the requirement to comply with a convention right, or that that would be of any real interest in some circumstances to the formulation of that convention right. Nor indeed, I should add, is that what the judgment at paragraph 98 decided. The submission and the focus of the judgment is on the relationship between Article 3 and the VCDR.
So the 5 cases...
The 5 cases are, firstly, Al-Adzani. I've taken you to that, and as I respectfully submit, it shows the very opposite. There's no sensible distinction between the VCDR and state immunity, unless it is to render the VCDR a fortiori, and all the reasoning flows. Mutatis mutandis. So I'm not going to go back to Al-Adzani. Matthews and the United Kingdom, that was tab 19, page 927. And there the Grand Chamber, as you will recall, held that the United Kingdom had violated Article 3 of Protocol 1.
Do you want us to get it up? 927.
Well, you can if you want. I'm going to make some submissions about it by reference to the paragraph, so it may be helpful to have it. But the Grand Chamber held, just to summarise the facts and the finding, that the UK had violated A3 of P1, which confers a right to free elections, because the citizens of Gibraltar could not vote in elections to the European Parliament. And the fact that they could not vote in elections was a consequence of the EC Act, European Communities Act, on direct elections of 1976, which the UK argued it could not unilaterally alter. And the Grand Chamber said that wasn't good enough. See paragraph 34 on page 962. But of course there are 2 critical points of distinction here. First, there is a different right that is in play. There it was an obligation to hold free elections. There was no scope for evaluative judgment. The relevant right was not conditioned in the way that the positive obligation is conditioned. It wasn't an obligation to hold free elections as far as was reasonably practicable, to use the shorthand. It was a hard-edged obligation. And secondly, as is clear from paragraph 34 to which I've just referred, the European Court's real complaint there was that the United Kingdom had entered into this EU agreement after it had entered into A3P1, Article 3 of Protocol 1, and the UK had subsequently taken steps to apply substantial areas of EU legislation to Gibraltar, but had evidently taken a policy decision not to extend the ability to vote in elections. Now, none of that, or anything remotely like it, is in play here. Although technically, of course, by a couple of years, the VCDR postdates the ECHR, it is common ground and clear that the core obligations contained in it, including the ones with which we are concerned, represented customary international law before then. This was a codifying convention. So we respectfully submit that Matthews and the United Kingdom doesn't take my learned friend anywhere. X and Latvia is the next one. That's tab 30, page 1438. And there, the applicant complained that the domestic courts in Latvia had breached her Article 8 rights by applying the provisions of the Hague Convention on Child Abduction.
Yes.
My learned friend, I think, referred you to paragraph 94, which in effect sets out the Demir principle. Demir and Turkey principle, with which of course we don't quibble. In fact, we positively rely upon it. But what the court then does is to go on to adopt a harmonious interpretation of Article 8 and the Hague Convention, which included ensuring that the Hague process respects the procedural requirements inherent in Article 8. There's no suggestion whatever that a state would be required to breach obligations under the Hague Convention in order to secure Article 8 rights. All they did was to say, well, we can imply, if you will, Article 8 procedural guarantees into the open textured wording of the Hague Convention. Nothing objectionable with that at all. Doesn't support the proposition that says you can breach it.
Well, it's a very different case.
It is. It is, but it's also not authority even for the proposition that they're doing anything other than harmonious.
I think he said that it's the submission really was that the ECA, the European Court of Human Rights, would not engage in a harmonising process of interpretation if it would prevent the court from performing its duty in full.
Well,
but I mean, I'm not quite sure what that meant. Those words are used in 94. I think it says, such consideration of international provision should not result in conflict or opposition between the different treaties, provided that the court is able to perform its task in full.
but ex and Latvia goes nowhere near that, whatever it may mean.
Well, I think
It's just an
as you
example.
say, you've got to look at what the court actually
Yes.
decided.
And it's just an example of harmonious interpretation. You get there.
Could you, without reading it out, just give us the paragraph numbers you rely on for that assertion? It comes after 94. Is it the whole? Is it really the whole of it?
I think it's the whole of it from there now. I'm
From
just summarising the reasoning.
97 onwards. Is
Exactly. Yeah, 97 and following. Can I move on to Al-Dulimi?
Yeah.
Al-Dulimi, tab 33, page 1615. This was a sections case, and to summarise, so tab 33, page 1615 is the start of it. It's a long old judgment, but this was a sanctions case in a nutshell. Switzerland had implemented UN sanctions imposed by way of a UN SCR, UN Security Council Resolution 1483 brackets 2003 on sanctions. And the applicant complained that the imposition of sanctions without, in effect, judicial involvement or supervision violated Article 6. That was the nature of the complaint that was being made in that case. And the position of the Swiss government, supported by the UK government, was that there was no room for manoeuvre in the light of the absolute nature, as it were, of the UN Security Council resolution imposed obligations. That was the nub of the dispute. At 134,
Is that paragraph?
paragraph 134 on page 1681, if that's the way you search. You have the Demir principle again not controversial. And in that case, just jump forward to paragraph 146, if you would. It's really 146 and 149, but in that case, as you see, what the court did was to interpret the relevant Security Council resolution, a bit like they'd done in Ex and Latvia with the Hague Convention. They interpreted the Security Council resolution in a manner that was consistent with Article 6, on the basis that there was nothing in the Security Council resolution which explicitly precluded judicial supervision. So it's a bit like the public law principle that says if an act of Parliament is silent about process, it won't take much for the courts to imply a duty of fairness into it. But that's the approach they're taking. They're grafting in something which hasn't been positively excluded and can be naturally and harmoniously interpreted into the international order, as it were, that was the UNSCR resolution.
And that's at 146.
That's 146. And as you see from 149, this was a case where the court was not in fact faced with a real conflict of obligations. There's no suggestion that a state should be required to breach its obligations under the UN Charter. So it was, if
contain
you,
any clear or explicit wording excluding the possibility of judicial supervision.
yeah, that's the essence of it. But this is again, therefore, a case of harmonious interpretation. It isn't a question of conflict of obligations. Sabi, I think, was the final of the five. Tab 26, page 1252. This was a case which Mr. Webster presented as demonstrating that the court was willing to require a breach of international law obligations relating to state immunity. And that, we respectfully submit, is simply wrong. In this case, what the European Court did was faithfully to apply the rules relating to state immunity, but they held that the domestic courts in France had erred in finding that that immunity applied in circumstances where the individual was not employed to perform any particular duties in the exercise of government authority. See for that purpose paragraphs 61 to 62 on page 1266. So 61 to 62 on 1266. And further, the European Court considered that the court, that's the domestic court in France, had failed to provide sufficient reasons for its decision that state immunity applied. See paragraph 67 on page 1267. And so far from showing that the European Court of Human Rights was willing to require a breach of the rules of state immunity, it shows the precise opposite. It was criticising the domestic courts for the processes by which they found, in the application of those principles, the criticism of the way in which the courts went about applying those rules. So there's nothing remotely close to a suggestion in this case that Strasbourg would contemplate an out-and-out breach or a dismantling of the position. And so we do respectfully submit that none of these cases comes within a country mile of what my learned friends would need to demonstrate, which is that in shaping a qualified positive obligation under Article 3 of a structurally similar kind to the kind that is frequently analysed under Article 6, the Strasbourg court wouldn't blink at the idea that in doing so it would place all of the contracting states in the Council of Europe in widespread breach of the rules of customary international law contained in the VCDR. So that's the fourth submission, the third and the fourth submissions, and it deals with the Strasbourg case law.
It hasn't blinked in the past.
It hasn't blinked in the past, and my submission is that you can be jolly confident it's not going to blink now.
Fully confident.
Well, that was going to be the alternative submission. You certainly can't be fully confident. The fifth submission, my lords, is the logic point. That's in part why I took you to the Sir Nicholas Bratzer Appellant opinion. I mean, one can pose a series of questions, and I'm not going to do this forensically in a dull way, but you can pose a series of questions as to where the logic stops if they are right. But what about the inability to prosecute or arrest for a crime impinging on any other Article 2 right. Article 2, Article 4, Article 8, the logic of the position extends far beyond the context of this case to any and all ECHR obligations of a positive kind. For example, if the UK is required to ignore its treaty and the customary international law obligations to accord diplomatic immunity in this case, it is very difficult to see why that logic wouldn't extend to risks to life, or to the possibility that someone was engaging in trafficking, or to the possibility that someone was unlawfully detaining someone, for example. So that's, as it were, the logic within the sphere of the ECHR. Why not other articles? What about the logic within the sphere of the VCDR itself? Why does the logic of the argument, which is essentially based on risk to children in Article 3 and the prevention of said risk, why does the logic of that argument not extend to a whole raft of provisions within the VCDR, including inviolability of the person, of the diplomat, inviolability of the premises, of the diplomat? And my learned friend Ms Gallagher was keen, forensically at various points in the submissions, to refer to behind closed doors. Well, you can only get behind the closed doors if you violate the premises. If they are right, Article 3 is to be regarded as not permitting any of this, and you have to take any and all steps to protect children against the arguable risk, and you can't scale down the logic. It's impossible to see where the principled endpoint is, and those would therefore be fundamental inroads into the customary international law regime that is the VCDR. Stand back even further. Why is it limited to children? If it's based on the hierarchical or structural importance within the scheme of the Convention of Article 3, why doesn't it apply to everyone? So those are the logic points. You see them. I'm not going to bang on about them, but you see the importance of them, because it does raise very serious questions as to how far this extends, and that is a legitimate analytical tool for the purpose of testing the nature and boundaries and content of the particular right under the ECHR, as we see from Al-Adzani. Sixth point, again I can take this very quickly because it relates to remedies, and we've discussed that at some length already. There is provision within the VCDR for remedies. They're the remedies that the contracting parties saw fit and were prepared to sign up to. No doubt they may be more constrained, perhaps slower, than remedies under general local law in the United Kingdom, but they do exist, and the remedies are conditioned to the context, including the basic premise that the VCDR exists and all its rules
But you'd
exist.
accept they're probably less effective.
My lord, they may be, in some cases, than the application of UK domestic law. I can accept that for the purpose of the principled argument. I should add that no one here disputes, as the point my lord drew out yesterday, my own friends accepted, no one here disputes the facts found in the divisional court's judgment below, including the operation of at least some parts, albeit on a consensual or consent basis, of the domestic structures. And we made a series of points on that in our skeleton at 52, and I don't develop them. But we note specifically in relation to the bespoke remedial regime, you've got waiver. And I made the point yesterday, so one can take it very quickly, that that is a waiver that is given by the state. It isn't the wrongdoing or the allegedly wrongdoing individual who has the ability. The state can waive. It didn't, in fact, do so here. But that is one possibility, and of course if the state does waive it, the state domestically can move very quickly. And you saw the basis from the certificate in supplemental bundle page 52, you saw the basis on which the invitation to waive was given. And that's important. A, because it grounds the invitation to waiver and alerts the sending state of the seriousness with which this government is taking those sorts of allegations. But B, it, as it were, operates as the initial precursor to the sending state doing what the VCDR envisages, which is, as it were, to assume jurisdiction under its own set of local rules and then apply those.
Well, in a sense, that would require an assessment as to whether our domestic protective system is better, the same, worse,
Quite.
different from. So you would need an individual analysis in each case to work out which remedies might be better.
Yes, and that would be
And that would be,
invidious and very difficult.
yeah. And if you look at it from the other perspective, they might have very different
Yeah.
decisions as to where the lines would be drawn.
They might have different mores as well.
They might. They might. And that's another point of significance that is attached to the number 190. So, my lord, all of those things. If the receiving state is not here, the UK is not satisfied, it can force the hand to some degree, immediate expulsion, persona non grata, and all of that. And of course, as you're aware, it's a procedural, not a substantive immunity. That was the point that Lord Sumption was keen to emphasise repeatedly in the Reyes case. And you see that expressly in the VCDR in Article 31, sub 4. So it's a procedural, not a substantive immunity. And so the basic position that is reached is that this is the system that the states have agreed, as it were, for the purpose of protecting the bubble that protects the operation of international relations. And to the extent that there is or there may be a deficit as compared to local law, that's in particular UK local law, which is highly developed in this respect for good reason, then that is because, to put it at its simplest, the diplomat has immunity and inviolability, and that is the function and effect of customary international law.
If it was a substantive immunity, AG couldn't be under a care order at all, could she?
If it was
A substantive, rather than procedural, then AG could not be under a care order at all.
That's true.
And she is, as we've heard.
Yeah. Oh, yes. But what that does in most cases, or in a large number of cases to which this applies, is it operates in effect as a conflict of laws rule.
Yes.
As it were, puts you into another jurisdiction.
Well, I would have thought that she could be under a care order because the immunity lapses
When they've gone.
Yes.
And the order was only made
Yes.
once
Yes, that's right.
they'd left.
Yes, you're right.
Yes.
Right, it's 18th of April and 20th of April 2020
Yes.
respectively.
Yeah.
So
Oh, yes. So from that point,
Yeah.
the point remains a valid one, because
she
before
could.
that you've got
If
the
she'd
dilemma.
if she'd escaped,
Yeah.
she could have been.
And perhaps the only thing to remind you of again is that on this set of issues about remedies is the Lord Sumption comment in Reyes at paragraph 7, recited in the judgment at paragraph 46, which I took you to yesterday. The truly wicked conduct bit, and recognising that the greater good exists, as it were. I wanted to pick up briefly under this 6th point, the non-refoulement point, which was principally a point about Article 9 that appeared, and persona non grata and removal and so on. And just very briefly in relation to that, we've dealt with it in our skeleton at paragraph 53.
I thought it was a point about Article 3 of UNCAT.
There is, I'm going to come to that. That's my 7th and final thing. I'm going to deal with UNCRC and
Okay.
UNCAT. Just to deal with non-refoulement.
Yeah, no, I thought the non-refoulement was based on Article 3 of the UNCAT.
I think it goes broader.
Okay.
I think there's a suggestion, a bit like there was in Al-Adzani, that torture's a ghastly thing.
Yeah.
I'm going to come to that. But whichever way it places, you can place it notionally there or notionally here. The non-refoulement point, we've dealt with our skeleton at paragraph 53, wasn't argued below. Article 9 of the VCDR is not within the scope of the DOI anyway. But in any event, there's no basis for assuming, it's kind of the discussion we had earlier on about the invidious nature of the inquiry that would have to be undertaken, a comparative exercise of respective goodnesses of local law systems. There's no basis for assuming that sending a child back will result in a breach of the non-refoulement, a breach of the non-refoulement principle. You can't assume, to put it in another way, that the foreign system will not be capable of picking up their concerns and dealing with them adequately. Indeed, the assumption is otherwise in the VCDR. That's the basis on which it operates. So we respectfully submit that non-refoulement doesn't add anything. I then turn, seventhly, to the UNCRC and UNCAT. That's the 7th point. And I start with the UNCRC. The UNCRC, we submit, can in principle add nothing by way of interpretation to Article 3 of the ECHR. And that is for the reason that was acknowledged by the Court of Appeal in AB. Supreme Court didn't need to go there, but the Court of Appeal in AB, which we've included behind tab 64. So tab 64, it's paragraph 74. And the core point that was being made there was you can't look at an international convention which contains wording which is virtually identical to Article 3 of the ECHR and then say the virtually identical wording can be used to interpret. It just doesn't add anything. And we know that Article 37A of the UNCRC contains the wording that it does, which very closely mirrors or tracks Article 3 of the ECHR. But that's the point that was being made by the Court of Appeal. The best interests of the child is a well-established general approach, of course, and the Strasbourg Court has frequently referred to it in its case law, and it's reflected in Article 3 of the UNCRC. But the key point is that the question here is how the positive and acknowledged duty under Article 3, conditioned as it is by reasonableness, proportionality, impossibility, and compliance with the law, and all of that, how that operates when you are in a context where the things that might impinge on the best interests of the child are in effect dictated by the VCDR. And again, come back to precision, because precision is probably the answer here too, as it was in Al-Adzani. It's no good to say torture's a bad thing, best interest of the child is a good thing. What you actually have to do is say, well, if I'm going to rely on the UNCRC and a principle in it to establish a proposition or a rule of international law of either equivalent, and I don't think it's saying greater status, because there's no argument about jus cogens in relation to best interest of the child, so it would be equivalent status of CIL, then you've got to be precise about what you're doing. And the question then is, in effect, does best interest of the child have to always trump and override and require states to breach the VCDR? So you're back to the same issue. And that is the point that the court below, I think, was interested in. And again, just for your note, the judgment below effectively made the forceful point that they did, I respectfully submit, at paragraph 112, leading to the impeccable conclusion at 116. So that's the UNCRC. UNCAT, the UN Convention Against Torture, again, not raised, hardly developed in argument, but similar points in answer. No doubt the attraction of relying on the Torture Convention is because, at least in some of its aspects, namely the state shall not torture itself, that would represent a principle of jus cogens. But as we've seen from Al-Adzani, that is not the correct way of analysing it. You do what they did in Al-Adzani. You apply the precision approach. You need to be very clear, if you are asserting a rule of jus cogens, that you properly and accurately identify the proposition that is said to be jus cogens. And you don't do that by making apple pie statements about torture. What you have to do is ask the question whether whenever there is a risk that something which may be characterised as torture is in play, you need to override the privileges and immunities. That's what they did in Al-Adzani. The answer was no in that context, and it's no here. But you also need, and it's perhaps an aspect of the same point, you also need to be very clear about the nature of the ECHR obligation that you're dealing with and you're considering. And here, as I've indicated on a number of occasions, we're not dealing with the negative aspect, we're dealing with the condition positive obligation. So that's UNCRC and UNCAT, very likely, if at all, developed orally for good reason, we submit, For those good reasons we submit. So they don't add anything. I wanted to finish on one point, which is that there is plainly an element. We submit it doesn't quite amount to this because it's a question of identifying what the nature of the right under Article 3 is. But there is plainly an element of irresistible force meeting immovable object in all of this, which is, I know, a point that my Lord the Master of the Rolls has put to me on a number of occasions. And of course, there is a choice in determining the scope of the positive obligations under Article 3. Systems, if you will, operational would do just as well, but systems, if you will. But that choice on the international plane becomes very stark. Abide by the clear terms of the VCDR and CIO it represents, recognising that the UNCRC, the Child Focused Treaty, in effect made no change to the VCDR, or conclude that the positive obligations under the ECHR must require the breach, and not merely a narrow breach in relation to civil jurisdiction, but a breach on its logic that would extend necessarily into other articles of the Convention, to people other than children, and in relation to a swathe of other articles in the VCDR, all of that. So that's the starkness of the choice, and my submission is, just to encapsulate the sequence question that my Lord Justice Moylan was taking me to task about. One, all the indications are that the European Court of Human Rights would not tear down the diplomatic house because the winds from which it protects international relations are very cold. And secondly, you certainly cannot be fully confident or confident that they would do so. No doubt it is possible to make a moral or political case based on the strength of concern for the well-being of children, for the amendment of the VCDR. But the UK cannot do that unilaterally. The Council of Europe states cannot do that unilaterally. The difficulties associated with some form of unilateral modification of the law or of the international legal position are considered at some length in Ms. Macmillan's statement between paragraphs 13 and 19 and are serious. And it's to be borne in mind by the court that there is an identified process. This is no doubt went to the initial note I gave you this afternoon about protocols, whether there have been amendments to the treaty and so on. There is an identified process for the amendment of treaties, and it's covered and dealt with in Article 40 of the Vienna Convention on the Law of Treaties, behind tab 62. But that would, unsurprisingly, given the scale, given the embedded nature, given the number of countries that are signed up, that would be likely to be a complex exercise. And I don't just put that up as an inter orem point. It would almost certainly have to be preceded by a body of work by the International Law Commission. And it would certainly have to address all of the complexities that would be involved in any such amendment, including grappling with the logical implications of any such amendment. How far does it go? Into what other aspects of the VCDR? What extent of inroad into the protection of international relations from the serious and clear and hard-edged rules that we've got in the VCDR? So it's a completely different set of issues, and it's no good, as I said yesterday, and this is my final point and then I will stop, but it's no good saying Parliament can do it, still less saying the government can do it. It's no good saying Parliament can do it. The question is whether there is an obligation within the positive obligation that Article 3 has recognised, qualified or inherently limited as it is, that requires that breach. And Parliament can't do anything about that. I mean, of course, technically, because the VCDR exists on the international plane and because the Diplomatic Privileges Act of 1964 is an act of Parliament and Parliament is sovereign, so can always change its previous law and can, if it so chooses, subject to whatever conventions, decide that it's going deliberately to breach international law. Of course, Parliament, as a matter of our domestic constitution, is technically able to pass an Act of Parliament that does that, but that is fanciful, we respectfully submit. And this is not a situation in which the dramas from our learned friend's case of having to acknowledge that this would involve a breach of a swathe of provisions of VCDR, that can't be ignored or swept under the carpet on the basis that don't worry about that, you can leave the detail to Parliament. If the court were to find that there was incompatibility, current incompatibility, structural incompatibility in our domestic system under Article 3 of the ECHR, then there would be no way of sorting that other than, in effect, to permit that swathe of breaches. This isn't about the minutiae of the detail, this is about that fundamental question. And it's that issue that lies at the heart of this appeal we submit, and it's that issue which ultimately and centrally persuaded the divisional court below, whose judgment we seek to support before you. And also, those are my submissions.
No, thank you.
Thank you very much, Sir James. Ms. Gallagher.
Just give me a moment. My Lords, at the outset of his submissions, Mr. Eady urged a harmonious interpretation in line with the Vienna Convention and used the phrase that we want to get to a place where all the provisions can work together. And he cited the VCLT and the Demir principle. Put shortly, our position is that this is a case in which it is simply not possible to have a harmonious interpretation as between Article 3's obligations and the relevant provisions of the VCDR or the DPA of 1964 as it transposed those principles into domestic law. Now, it's been presented to you as if you essentially are in a position, the invidious position, of having to, in a league table, assess these two competing principles. My Lord, the Master of the Rolls yesterday made a very powerful point, indicating that, of course, you've heard very powerfully from one side about one key principle, and you've heard very powerfully from the other side about another key principle. And this, in our central submission, is a situation in which those two cannot be read harmoniously. That's why we say we're in the territory of irreconcilable clash. Now, the way it's been presented is that on the one hand you have clear, well-established, long-running, cast-in-stone type obligations under the VCDR, and on the other you have a non-absolute provision, because we're dealing with the positive aspect of Article 3, which in itself has a form of qualification or iterative process. And the suggestion is that faced with those two things, one must give way. And our submission is, firstly, the description given of the VCDR is not in fact accurate when we look at it more closely. And secondly, the description of the nature and purpose of the system's duty under Article 3 has also been misstated by both the Divisional Court below and by the Secretary of State again. So I'm going to run through those 2 points and then pick up a number of specific additional points arising from my learned friend's submissions. So let me start, first of all, on one side of the scale with the VCDR itself, the nature and effect of the VCDR. Now, that, of course, is extensively dealt with in the Divisional Court below, and for your reference, the provisions of the DPA and the VCDR are dealt with extensively at paragraphs 36 to 44 of the judgment. It's core bundle, page 40 to 42. The nature and importance of the VCDR in the operation of diplomatic relations is at 45 to 46, paragraphs 45 to 46, core bundle, page 42 to 43, quoting extensively the dicta of Lord Sumption in Rees. And the application of the general rule of treaty interpretation as provided by Article 31 of the VCLT to the interpretation of the terms of the VCDR is dealt with at paragraph 47 of the judgment 56, again quoting extensively the dicta of Lord Sumption. We dealt with that in our skeleton. And my Lord, the Master of the Rolls, indicated yesterday that on our side we hadn't reflected the importance. Much of the principles which are set out by the Divisional Court are uncontroversial. We don't take issue with them. We do take issue with a number of the points made by the Secretary of State yesterday when he ran through his 8 points. First, he, I think it was his 6th point, dealt with the notion that the VCDR provides a remedy, and he returned to that today. The VCDR does have potential remedial measures within it. The persona non grata declaration. The receiving state may express its displeasure by, for example, imposing a cap on the size of the diplomatic mission. That's Article 11 of the VCDR, dealt with in paragraph 14 of our skeleton. The receiving state may ask the sending state to waive diplomatic immunity, see Article 32 of the VCDR. May expel the diplomat as a persona non grata, Articles 9 and 43. Or indeed may sever diplomatic relations with the sending state and require the mission's immediate closure. Mr. Eady was at pains to say yesterday that they can operate quickly where so required. Now, those remedial measures are of course linked to the very object and purpose of the VCDR, or to use Mr. Eady's phrase, the remedies are conditioned by the context. And the context, as summarised in paragraph 12 of Basfer and Wong, don't ask you to turn it up now, but it's page 780, is of course that the VCDR is designed and crafted not to benefit individuals, but to ensure the effective performance of the functions of diplomatic missions. It's to govern interstate engagement. So what you have in these remedial measures is essentially ways of marking discontent with the sending state, with the diplomatic mission, or with their individual personnel. And that's why in many of the cases where you're looking at an ex post facto issue about whether or not you can, for example, sue the diplomat, it's quite different to the circumstances we're dealing with here, where there's an issue about immediate protective steps being needed. Here, at issue is circumstance in which all other children within the jurisdiction, save for the children within that 23,000, who need immediate removal under the provisions of Part 4 or Part 5 of the Children Act 1989, or at the very least require immediate assessment in line with Section 47. Here, this particular category of child cannot avail of those. Being able to close the mission doesn't assist. Indeed, it may be counterproductive. Being able to declare the person persona non grata is a mark of displeasure, but it doesn't in fact deal with the core gap we're dealing with here, which is the inability to take those immediate protective steps. Now, my Lord the Master of the Rolls yesterday to Mr. Eady said, you don't deny that it would be more effective if the full gamut of the 1989 Act provisions could be applied. And the answer to that was, there wasn't a denial that it could be more effective, and you were given the answer that lots of things are sorted out interstate. But that sorting out interstate doesn't deal with the immediate nature of the risk, the immediate nature of the requirement for removal, or at a minimum, assessment. And my Lord Justice Moylan asked a question just now about the invidious position of having to analyse competing systems. But that goes to longer term issues. And here, when we're dealing with the immediate steps, what do you do in circumstances where a local authority or the police has credible cause to believe that a child in an embassy is being raped by a diplomat, is being assaulted by a diplomat, or indeed even to use the very stark example from Mr. Eady yesterday, is being murdered by a diplomat. Now, the genuine exemption, the genuine emergency exception, might deal with a risk to life, because that's how it's been developed so far at international level. But it doesn't deal with an immediate issue where there's Article 3 violative conduct taking place, or Article 3 violative conduct suspected of taking place. And those VCDR remedies, which go to a very different issue about the performance of diplomatic missions and interstate engagement, about functions of diplomatic missions, has nothing to say in this particular context. And that's why we say this case is so very different to the many cases concerning Article 6 and ex post facto issues. One of the reasons we say it's very different. The third point, which Mr. Eady went to, I'm going to them in a different order for reasons which will become clear. He said the privileges and immunities operate to protect those to whom, even when they are accused of the most serious conduct. What Lord Sumption at paragraph 7 of Rees described as truly wicked conduct. And that's when he gave you the very stark example of the murder of a child. But may we look at paragraph 7 of the Rees case and what Lord Sumption said. So we find that it's behind tab 10, starting at page 532. It's in the first volume of authorities, second volume of authorities, so volume B, starting at page 532, tab 10. And that phrase about truly wicked conduct is at page 547. And it's in the context of Lord Sumption referring, citing the ICJ decision in Congo and Belgium from 2002, diplomatic immunity is not an immunity from liability, it's a procedural immunity from the jurisdiction of the courts of the receiving state. The receiving state cannot at one and the same time receive a diplomatic agent of a foreign state and subject him to the authority of its own courts in the same way as other persons within its territorial jurisdiction. And you see down below F, there's the reference to wicked conduct. The context is this. He says, if you look at point E, just a little higher on, the diplomatic agent remains amenable to the jurisdiction of his own country's courts, and in important respects, to the jurisdiction of the courts of the receiving state after his posting has ended. I do not underestimate the practical problems of litigating in a foreign jurisdiction, especially for someone in Miss Rees's position. Nor do I doubt that diplomatic immunity can be abused and may have been abused in this case. A judge can properly regret that it has the effect of putting severe practical obstacles in the way of a claimant's pursuit of justice for what may be truly wicked conduct. But he cannot allow his regret to whittle away an immunity sanctioned by a fundamental principle of national and international law. So the context there, referring to truly wicked conduct, is in relation to an Article 6 type issue, where in fact the very essence of the right is not extinguished, because ultimately, as Lord Sumption makes clear, although there are practical hurdles, there is access to a court, it's access to a court in another jurisdiction. But that doesn't say anything to a situation where you have truly wicked conduct, which is Article 3 violative, occurring at a time when there is a need for immediate action, immediate removal, or at a minimum, immediate assessment to see whether immediate removal is required. And on a separate point, Mr. Eady referred to diplomatic immunity being procedural, not substantive. It's not immunity from liability. And we agree with that, and it's an important point. And it's why those Article 6 cases are very different, because you're not dealing with personal immunity here, it's functional immunity. It attaches to the individual whilst in the receiving state, whilst performing their role. And it means when you're looking at longer term mechanisms for attempting to seek ex post facto accountability, there's a range of options. You can have, as in some of the trafficking cases, a situation where the diplomat is no longer in post. You can have, as per paragraph 7 of the Rees case, a situation where, although there are practical obstacles, you have access to a court in the other state. But those are quite different to the scenario that we're faced with here. The 7th point Mr. Eady made, running through his 8, he said there's a fundamental benefit in the VCDR operating on the basis of clear, well-established and long-operated rules. But importantly, I'll come to some specific examples of this, that does not mean the VCDR is set in stone, or that its remit and its limitations and its boundaries are necessarily immediately clear. See, for example, number 1, the genuine emergency exception. You can take it to the Tehran case. We gave you right at the outset that example, also used in the skeleton for the Secretary of State in the court below about the drunken ambassador in charge of a vehicle. Now, that doesn't appear on the text, nothing to indicate what the position was in 1961 or 1964 as to the genuine emergency exception, and we've seen it arise in a range of circumstances. We've seen it indeed played out in the media over the last number of weeks with the gentleman at the Chinese consulate in Manchester, with the argument being made by Greater Manchester Police they had to intervene to bring him back into the jurisdiction because it was a genuine emergency situation. We've seen it in stark terms in the Bahrain embassy with the protester on the roof. So that is an exception which has been carved at international level since 1961, since 1964. Article 31(1)(c) itself refers to the context in which the principle of diplomatic immunity must be seen, referring to subsequent agreement between states, subsequent practice, which encompasses the genuine emergency scenarios, and also relevant rules of international law applicable in relation between states. But a particularly stark example is the situation in respect of trafficking and what the Article 31(1)(c) exception means. And if you still have the Rees case open, could I ask you to look at Lord Sumption at paragraph 43, and it's page 564, the electronic bundle. Now, this, of course, is the circumstance in which Lord Sumption's in the minority about what would have been said on the hypothetical question about whether the exemption would apply here. And he says at paragraph 43, the first objection to the argument that was made on behalf of the woman alleging trafficking, person alleging trafficking, is that no such intention can be discerned in Article 31(1)(c) of the Convention on Diplomatic Relations. The concept of a professional or commercial activity exercised by a diplomatic agent is not ambulatory. The expression does not express a general value whose content may vary over time. It's a fixed criterion for categorizing the facts, whose meaning and effect was extensively discussed during the drafting and negotiation of the text. There's no reason to suppose that it refers today to anything other than what it referred to in 1961. Then at paragraph 44 and onwards, he refers to international obligations in relation to human trafficking not being of the same nature as the VCDR. It's a very similar tone of arguments to the ones that you've heard made here in respect of the obligation in relation to children. Now contrast that with the approach taken by the majority, starting at paragraph 57, page 569 onwards. That's the judgment of Lord Wilson, with whom Baroness Hale and Lord Clark agreed. Of course, it's in the context of them saying we don't have to answer the question. Lord Sumption's emphatic answer to the question is no. His answer is, if he will forgive my saying so, the obvious answer may be correct, but my personal experience has been that the more one thinks about the question, the less obviously correct does his answer become. And you then have the analysis which refers to those factors I indicated in outline yesterday about the significant problem in relation to the exploitation of migrant domestic workers by foreign diplomats. We say a principle which also applies here when we're referring to abuse or suspected abuse of children of diplomats. And you have the evidence before you from Barnett, as the divisional court did, and you have the statistics not disputed, the 23,000 statistic, and also the factor about the universal condemnation in the international community of human trafficking and a determination to combat it. So the majority highlighted those issues and expressed doubt about Lord Sumption's emphatic no. And what we then see while we're in this paragraph is, and I had this in mind when my Lord the Master of the Rolls yesterday was essentially saying, is this something with which we have to grapple? You'll see at paragraph 68 a relief from Lord Wilson. It's at page 572 to 573 that he and his colleagues were not put to that test today. It wasn't something that they in fact had to decide, and he recognised the complexity and difficulty of it. Now, and of course you'll then see paragraph 69 for completeness, Baroness Hale and Lord Clark agreeing with the doubts expressed by Lord Wilson and disagreeing with Lord Sumption in the minority on his approach as to what would apply. Now fast forward 5 years, you then of course have the Supreme Court in Basfor and Wong, again not clear cut, it was a majority decision, Lord Hamblin and Lady Rose dissenting.
Which case?
That's Foreign Wong. It's tab 16 in the same bundle, page 774 onwards. And key point here is that between those two cases, you have a situation where the Article 31(1)(c) exemption was the subject of a split decision by the Supreme Court in 2017, Lord Sumption being in the minority and giving an emphatic no, the majority expressing doubt, recognising it was a difficult issue. And 5 years later in Basfor and Wong, you have another split decision of the Supreme Court about the remit of that exception under Article 31(1)(c), Lord Hamlin and Lady Rose dissenting, but the majority taking the view that in fact that exception, commercial activity outside the diplomat's official functions, it does mean that there is a remedy available in respect of trafficking. Now I say that because the presentation of the VCDR as being clear, well-established, long-operated rules on the one hand, on one side of the scale, versus on the other hand, this qualified, restricted right under Article 3 because we're not in the absolute territory. So on one side of the scale we say the way that it's been put is too high. And it's not reflected when you look at what's happened since 1961, particularly in respect of genuine emergency exception, and a very clear example with those two Supreme Court decisions in relation to the Article 31(1)(c) exception. And I should say the phrase used by Lord Wilson in paragraph 68, the 2017 decision, was he recognised it would be, I use his phrase, a strong thing to diverge in circumstances where there was in fact authority from another contracting state, from the US, suggesting a different approach. He recognised it would be a strong thing to diverge. Nevertheless, the majority in Rees Obiter expressed the view hypothetically that they may be minded to diverge. And now a majority of the Supreme Court in July 2022 has diverged. So that's one side of the scale. So we agree entirely with the vital importance of the VCDR, and I'm afraid with limited time and in circumstances where the divisional court's paragraphs in relation to that are largely not in dispute, it was taken by myself and the local authority rather quickly for precisely that reason, because it doesn't get us to the nub of the case. But the way it's been put by my learned friend, we do take issue with it in that way. We also take issue with how my learned friend has presented the Article 3 obligation in question in this case on the other side of the scale. And there's a number of points to this. Now, he urged precision quite a few times. It was a phrase that he used repeatedly, as if we were being imprecise. And I'm afraid we say what's sauce for the goose is sauce for the gander. And the approach that he's taken also was imprecise and difficult. Because when he referred to the positive obligations, he said there are three things of note when you're looking at the positive obligations. Bearing in mind here, we are dealing with the systems duty. So we're not arguing that there was a breach of the operational duty in the individual case. We're not saying that Barnet or the Metropolitan Police could have done more because their hands were tied for systemic reasons. We're also not saying that there was a breach by Barnet or the police of the investigative obligation. Now, when you were given the description of the positive obligations this morning, the description was the negative obligation is an absolute. The positive obligations are conditioned by reasonableness. And he said, in essence, there's two types of positive obligation, a structural legal framework obligation, and secondly, an operational duty, the Osman duty. Now, in fact, we say, supported by the authorities, you've got the references in our skeleton, and I'll take you to the Rabone paragraphs if you need to check it. There are essentially three strands to the positive obligation, two of which are substantive, one of which is procedural. And they're all very important together. The first is the systems obligation. And that's the obligation in relation to both the structural legal framework, but also enforcement of that structural or legal framework. Both I and Mr. Webster took you to the cases yesterday which make clear that that systems duty has both the letter of the law and practice, implementation. The second substantive obligation is the specific operational duty which arises in what's been described by Strasbourg and in the domestic courts as arising in well-defined circumstances, certain well-defined circumstances. See paragraph 116 of Osman, conscious Osman also hit the cutting room floor when you were receiving the bundles, so if you do need us to provide that, we can of course do so. But paragraphs 115, 116 of Osman, which have now been played out subsequently in a whole range of cases domestically and a whole range of cases in Strasbourg, including the rubbish tip case on Yildiz, which you do have in the bundles. A whole range of cases in which the well-defined circumstances have been expanded. That relates to individualised decision-making in individual cases relating to a known risk and what reasonable steps can be taken. Now, here, and we then also have the third strand, which is important, which is the investigative obligation. And the investigative obligation, of course, has a much lower threshold, because if, to trigger an investigation, you necessarily don't yet know if there's been a breach of the substantive obligations. And that's why you have the cases which say there's a credible allegation of there being a breach of the substantive obligations, whether that's the systems duty or the operational duty, the Osman type duty. That's why you've, of course, so many cases where an inquest proceeds on the basis of Article 2 and then, in fact, ultimately there's no breach of Article 2 found when you look at the facts, for example. So that's important because the investigative obligation can also only be triggered when you have credible evidence of a potential substantive breach. Now here, the suggestion was that there are three things of note when looking at the positive obligations. That was the point made by Mr. Eady this morning. And he gave 3 points. And we say he's conflated the operational duty and the systems duty in making those points. First, he referred to the concept of reasonableness. Second, he referred to the importance of not imposing an excessive burden on the authorities. And then thirdly, he referred to the phrase within the scope of their powers. Now, third one is very simple. The within the scope of their powers test is from the operational duty. See Osman, paragraph 116, see Honor Yildiz, see Rabone, all of the cases that you have before you on the operational duty. And within the scope of their powers is not a test which you see in relation to the systems duty. It's a different phrase. Now, we go back to reasonableness. Reasonableness means quite different things.
Sorry, what did you say?
So when we go back to the reasonableness concept, apologies, my lord.
Sorry, yeah.
Reasonableness is conditioned closely by the context. And what reasonableness means in relation to the operational duty is not the same as what reasonableness means in relation to the systems duty. Also here, the nature of the systems duty that we're dealing with is quite different to many of the cases before you, which is why you have a rainforest of papers, or the electronic equivalent, and no cases which are directly on point. Because so many of the cases relating to systems duties concern things like, for example, the requirement on the state to have a system of ensuring that you have ambulances to dispatch to home emergencies. See, for example, the Humberstone case, which we refer to in paragraph 23 of our skeleton. And in answer to questions yesterday, I accepted that the systems duty doesn't require a particular result. So you can have a situation, of course, where someone calls 999, requires an ambulance, and there's good reason why an ambulance cannot be with them immediately and doesn't save their life. So in the context of that kind of case, reasonable practicability is linked to logistics. Must you have a fleet of 9,000 ambulances? Do you have good reason to have only a fleet of 500 ambulances and a sensible system of prioritisation in order to comply with your system's obligation? But here we're dealing with something quite different, because here the systems challenge that we have, supported by the local authority, is that there's a whole category exemption. So this is the equivalent to saying ambulances aren't dispatched to embassies, or ambulances aren't dispatched to prisons. It's a wholly different thing to many of the cases which refer to the systems duty. But the next phrase that he used was not to impose an excessive burden on the authorities. And may I go to the case that he relied on heavily, the one from the new bundle this morning. So that is, this is the Smiljanic case, tab 65, and you were taken to paragraph 70. And that begins, paragraph 70, on page 315. And Mr. Eady urged you to read the paragraph in context. We agree, and this is some more homework for you.
Sorry,
because
if
when
you just bear with me a bit, I'm not quite
course.
sure I've got...
I'm so sorry, my lord. It's the bundle from the Secretary of State. So I think the first supplementary bundle. It's not internally paginated.
Which page is it?
This paragraph 70 is at page 315 of the judgment. 234 of the electronic bundle, I'm told.
Thank you.
And
Yeah.
you may, my lord, have it in your note as the Croatia case, if that assists.
Yeah, I've got it. Should be emphasised.
I was attempting, it's something that comes from having a name like mine. I was attempting to pronounce the other name with the many consonants in it. Do you sometimes get told my name is like an extract from an optician's wall chart? And perhaps some of the cases you have before you suffer from something similar. Let's call it the Croatian case. But paragraph 70 uses that phrase, excessive burden on the authorities. Do you see it? Second line down. It should be emphasised that the positive obligation is to be interpreted in such a way as not to impose an excessive burden on the authorities, bearing in mind in particular the unpredictability of human conduct and the operational choices which must be made in terms of priorities and resources. And when you see that phrase about excessive burden on the authorities, it goes hand in hand in the Strasbourg authorities with that reference to unpredictability of human conduct, operational choices which must be made in terms of priorities and resources. We see that in the operational duty cases like Osman, where precisely as the point was put yesterday, you may be in a situation where the only way to fully protect the life of someone who's at risk may be 24-hour surveillance or having a fleet of officers who are looking after them constantly. And of course in that context, reasonableness, whatever the qualification phrase is, it differs a little in the authorities, refers to operational choices which must be made in terms of priorities and resources, and also unpredictability of human conduct. That also makes sense when you're thinking of the systems duty in the sense of how many ambulances do you need to have in order to adequately protect life. But it simply doesn't apply in the same way in this context. Now may I ask you to look back, paragraph 64 onwards, the substantive aspect of Article 2, so the entirety of this section, which finishes with paragraph 70. Refers in terms, paragraph 64, to Article 2. We're looking at the equivalent obligations in relation to Article 3. The state to take appropriate steps to safeguard the lives of those within its jurisdiction. We're dealing here with the equivalent, the appropriate steps to safeguard from Article 3 violative conduct. Children within its jurisdiction, including the AG and others in her category. And then the case is about road traffic. So you see paragraph 65 onwards, it deals with what's required in relation to Article 2 and road traffic. And at the bottom of page 313, it says it should be further stressed that in view of the fact that the object and purpose of the Convention requires its provisions to be interpreted and applied in such a way as to make its safeguards practical and effective, Article 2 requires the domestic authorities to ensure the effective functioning of the relevant road safety regulatory framework. And the description given in paragraph 65 about what the core obligation is there must be put in place a legislative and administrative framework designed to provide effective deterrence against threats to the risk of life, and then it's got to be implemented. So framework and implementation. And you then see the phrase again in paragraph 66, that in sum, the last sentence, the state's positive obligation under the substantive limb of Article 2 extends to a duty to ensure the effective functioning of the regulatory framework adopted for the protection of life. And ultimately, that's what we say is missing here, and where the divisional court fell into error below. Because here, the system's failure in question here is that there is no applicable legal framework and consequently no implementation of the framework which protects this category of child from Article 3 violative conduct. Simply because of their status, they do not have that protection. You see again down at paragraph 69 again that reference to an appropriate set of preventative measures geared to ensuring public safety, minimising number of accidents, and secondly ensure the effective functioning of those measures in practice. So when you then go over the page onto paragraph 70 and you then read in context what they mean by not imposing an excessive burden on the authorities, you'll see halfway through the paragraph it says, thus, where a state has adopted an overall legal framework and legislation tailored to the protective requirements in the specific context, matters such as an error of judgment on the part of an individual player or negligent coordination among professionals, whether public or private, could not be sufficient of themselves to make the state accountable from the standpoint of its positive obligation under Article 2. We're in wholly different territory here, because in this specific context, in relation to children of diplomats, there is no overall legal framework and legislation tailored to the protective requirements in this specific context, using the language of the Croatian case, paragraph 70. We're not dealing with the situation where there is an overall system in place, and what arises is, did the London Borough of Barnet or did an individual Metropolitan Police officer make an error which exposed the child to Article 3 violative conduct? We're in a wholly different scenario, and that's precisely why we say this is a situation in which there simply is no way of reading the matters in a consistent manner. We're dealing with an irreconcilable clash. Now, it was put to us on a number of occasions that we were arguing for supplanting the provisions of the VCDR, usurping them in some way, and that's not accepted. If we were arguing, in line with the approach taken in those first instance cases, which you've also been provided with, that this is a section 3 point, this is a reading in or reading down point, that point would have some force. But that's not the situation here. What we're saying, the position is here, is that we're not suggesting in any way that the VCDR is void or unenforceable. It would remain binding. You don't have a strike-down power. The UK would then be faced with the political choice about how to respond. And because here, the approach that's taken by the Divisional Court and by the Secretary of State is the VCDR is fixed, Article 3 must bend.
But do you accept that it has to respond if we make a declaration of incompatibility?
Well, as a matter of international law, we say yes. But of course, as has occurred the state may take the view, and I'm thinking of cases such as the prisoners' voting case, for example, where Strasbourg made clear what the position was as a matter of ECHR interpretation. And the political decision which was then made differed. In fact, the step was not then taken. But the point is here, and I understand entirely the discomfort that was expressed yesterday. I'm so sorry, my lord. Did you have another question?
No.
So on this point, we entirely understand the discomfort indicated from your question yesterday, because this is not territory which you would ordinarily be in. And whether we use the language of Nicholson, the Supreme Court, about functional competence, whether we use the language from the margin of appreciation cases, ultimately, we're in a position where what you're being asked to do, in effect, by the Secretary of State, is you are being asked to enter into the area of international relations and consider the respective merits of these two very, very powerful principles enshrined in international law, now enshrined in domestic law. In our case, Article 3, enshrined through the Human Rights Act 1998, but also the principles in the Children Act 1989. And on the other hand, the DPA 1964, enshrining the provisions of VCDR 1961. And we entirely accept and understand why that's an invidious position for you to be put in. The approach that the Divisional Court took was the Divisional Court said, well, in fact, paragraphs 94 to 98, the system is effective. So that's a sidestep. They said the system was in fact effective. It played in a way here that was effective. Might not have been quite as effective as it would have been for other children, but it was effective. And central to our case is it was not effective. And that's why we've taken issue with the lead up to paragraph 98. And our view, and the position that we get to, is that the appropriate course here is for you to do what the very first judge who was dealing with this case in early 2020 did, and say this is an irreconcilable clash. And it is entirely open to you to do that. Now, in other circumstances, you might be urged to take a hands-off approach when faced with these kind of highly political decisions concerning international relations. And here, the less controversial approach in many ways is in fact to say, we can't resolve this clash. That's why you have a fully available to you, carefully crafted provision under the Human Rights Act of a declaration of incompatibility, and the baton passes to someone else. Now, that's not us saying it's above your pay grade, the phrase used by Mr. Eady yesterday. It's a functional competence point. But ultimately, this is a point, a highly political point, which should be determined by the UK. And regardless of what reasonably practicable in this particular untested context of international relations may mean, it's clear it's got to mean something. And at present, there's no evidence before you about the UK having taken any steps to try to deal with this, whether that is taking the kind of action that the majority in the Rees case urged in 2017 when dealing with trafficking, about approaching the International Law Commission and so on, or some other step. There's no evidence of anything having been done here. I do want to deal just very quickly with, mindful of the time, a couple of quick points. The first is the AB case. And in respect of the AB case, apologies, just take it out of order. So, my lords, just while I'm finding my own reference,
I think you told us yesterday that all those paragraphs were not relevant.
So, my lords, what I wanted to say is that in both the Rabone case and the case we were given just now,
yes,
I'm so sorry, I just don't have my reference.
What are you looking for?
I just have a note with the relevant paragraphs which I want to take you to in another case. I'm so sorry. Just give me a moment.
Do you want AB or not?
It's not AB, it's in Rabone, in fact.
Right, well, the
And
bone,
it's the...
bone is...
Page 79.
Yes, that's right. Well, you know, somehow... I don't have it. I'll just have to manage without it. But I can deal with it here.
The line passage is page 9, paragraph 93. Is that where you want to go?
Yes, of course. Could I just ask? I'm going to deal with another point just out of order so that my junior can just assist me with it. In fact, I've got it. I'm so sorry. I'm so sorry. I realise time is tight. So, in these circumstances, the AB case deals with a wholly different situation. You've gone to the paragraphs in AB, and I took you to the paragraphs yesterday in relation to the nature of the case. And what was being urged in AB was a U-turn on settled Strasbourg jurisprudence. And you've got the paragraphs in AB which make clear that what the appellant was seeking in that case was a wholly different approach to that which was clear, settled, long established in the Strasbourg case law. And we are not in that territory. Similarly, the case which you were given this morning concerns a situation where you have long established principles in the case law, and the approach was...
You mean Ellen Kane?
Yes, that's right. And the argument that's made is to take a different approach. Now, here we say we're much more in the territory of Rabone, and that's why I just wanted to give you the key paragraphs. Given the time, I'll just give you the references. It starts at page 79, thank you, volume A of the Authorities, tab 4. The leading judgment is given by Lord Dyson, with additional observations by Lady Hale and Lord Mance. And key issue with Lord Dyson is at page 118, at page 120, paragraph 118, where, that's Lord Mance. Lord Mance at paragraph 118, page 120, refers to factors that you can use to identify what the Strasbourg court would do when you're dealing with a blank slate case where the issue's not been decided. Or the phrase used by Lord Dyson at paragraph 22, page 93 of the bundle, he uses two phrases. He says, no decision of the European Court of Human Rights has been cited to us where the court clearly articulates the criteria by which it decides whether an Article 2 operational duty exists in any particular circumstances. It's therefore necessary to see whether the cases give some clue as to why the operational duty has been found to exist in some circumstances and not in others. There are certain indicia which point the way. So the phrase of Lord Dyson's is a clue or indicia as to what the principles are, and the phrase used by Lord Mance is factors. So in Rabone, what you were dealing with was no case on point, and not even, as reflected in the leading judgment here, not even a situation in which the European Court of Human Rights had clearly articulated the criteria by which it would decide whether an operational duty arose.
Is that inconsistent?
So the point is here that what you get is you get the Supreme Court in Rabone delving into the cases to see, well, where are the factors, what are the clues, what are the indicia?
Why is that inconsistent with AB?
Well, it's not inconsistent with AB. We don't disagree with the principle in AB in that particular context. We say we are not doing what the appellant sought to do in AB. Where the appellant in AB said,
No, I get that.
there may be a series of these cases in relation to Article 3 which say fact-sensitive analysis. We say don't adopt a fact-sensitive analysis, and we say that by reference to UNCAT, what's been said in general observations of the United Nations Committee on the Rights of the Child, and other unincorporated international materials. So that's what they did there. That's the context in which the Supreme Court says no. But in Rabone, what you have is you have a situation where there's no case yet decided, it's a blank slate case, but you get the court examining what are the factors, what are the clues, what are the indicia as to the principles which would be applied, and they identified control, assumption of responsibility, nature of the risk, the particular importance that's placed on the protection of vulnerable people, for example. And similarly here, what both we and the local authority say is that when you examine the factors in relation to the nature of the Article 3 systems right, and when you look at what Strasbourg says about children and vulnerable people, whilst you're not dealing with an absolute right, you're dealing with something which is certainly extremely high in the pecking order and is not equivalent to the qualified rights in Article 10, 11, or indeed Article 6.
But do you say we can be fully confident or confident?
Yes, so the phrase used, we do say, our primary position is yes, that you can be fully confident what Strasbourg would decide. And both we and the local authority say, yes, you can be confident what Strasbourg would decide in these circumstances. And that Strasbourg, in circumstances where, adopting references made by Mr. Webster yesterday, in circumstances where the focus within the ECHR system is on ensuring practical and effective, not theoretical and illusory protection of rights, where there's a recognition of the particular vulnerability of children and heightened obligations in relation to children, and there's a recognition, see the paragraphs in the Croatian case, paragraph 64 onwards, to refer to the central importance of Article 2 in that case and the equivalent in relation to Article 3 cases, occupying a central point within the convention system. Our position is, yes, you can be fully confident. But may I say this, a fallback at a minimum is that the divisional court, in saying the opposite, was quite wrong. And when the divisional court said, as it did in paragraph 98, or indeed as Mr. Eady has said in his submissions, that you can be confident Strasbourg would decide it the other way, that's quite wrong. So our primary position is we're fully confident that Strasbourg would decide that there's a conflict here. But if I may, as a fallback, we're at the very least in a grey area which is quite different to what the divisional court said in its judgment, being confident that the VCDR would win the day, simply not comprehensible in circumstances. Final two very quick points, given the timing, is in relation to Al-Adsani. The Al-Adsani case, of course, was a very close-run thing, 9-8. And we're conscious that you were referred overnight to that concurring opinion, Judges Bratza and Palompa, with respect to the must be precise point. And we make two short points. At first, their analysis is such a finding would mean that you would place an additional burden on states that accept refugees to guarantee access to the court to determine their claims for compensation for alleged torture. See O, Roman numeral 2, 3, at tab 21, page 1058. The consequences of a finding in this case are quite different. Now, first of all, the immediate consequences are that nothing in fact happens. The baton's passed to Parliament. In any event, the ramifications of the finding are that the state must provide for effective protection of children of diplomats from torture, inhuman and degrading treatment. Simply not analogous to the kind of scenario that was being looked at in Al-Adsani in the context of Article 6. Second point is that there was then at page 1059 to 1060, or O Roman numeral 2, 8, there was the argument that by holding state immunity from civil suit, it would breach Article 6 because of the Jus Cogens nature of torture. The consequence would be that they would need to find that immunity from execution of judgments against property of the state. And there was this reflection on Pyrrhic victories. And there's no analogy here. This isn't a Pyrrhic victory type case in that way. The state would be doing all that is reasonably practicable to protect this category of child. And that in itself is fundamental to ensuring the prohibition of torture. Protection from torture and ill treatment by state or non-state third-party actors is central to enforcing the prohibition. And I think the final point that I just wanted to make is that a number of the cases that have been cited are just so wholly different that they don't assist. Estrada, for example, which we've gone to at some length, is an Article 6 case and a divorce case. And of course, reasonableness may differ as between Article 6 and Article 3. And what's reasonable or proportionate to protect in respect of Article 3 mistreatment, where there is an immediate need to act, or at the very least, an immediate need to assess, plainly is not going to be equivalent to what is reasonable or proportionate in respect of Article 6, particularly in a case of diplomatic immunity, where ultimately, as per paragraph 7, Lord Sumption in Rees, there is ultimately, with practical obstacles, a potential recourse to a court elsewhere. So the right hasn't been extinguished. This is a wholly different scenario. So this is not as a case as obviously in the open air as a protester being pulled by the hair into the Manchester consulate grounds, or a drunk ambassador on the street who's then taken into police custody so he can sober up. We're not dealing with that kind of risk here. We're dealing here with a risk which is dealt with by family courts, by local authorities and by police day in, day out across the country in a way which protects vulnerable children, and children where there is a credible risk or indeed even a known risk that they are suffering Article 3 violative conduct. And the position adopted by the Divisional Court is that there's a category exemption for this entire category of child. And our position is that that is unconscionable, simply unsustainable to say that there's a harmonious way of reading that approach by the Divisional Court with Article 3's requirements, underpinned by the additional international law material cited in our skeleton by the local authority. This is a domestic law point about whether there is a harmonious way of interpreting those two things. We say it can't be done. There is an irreconcilable clash. Declaration of incompatibility and passing the baton elsewhere is what should be done here, unless I can assist further.
Thank you.
If there is any additional point, I'm afraid my hearing is not great, but I did hear she hasn't dealt with. If there is any additional
well, you want to say something about the logic points in a sentence, because we've got to rise at 5:30.
I'm very conscious of that, and I am conscious that both ourselves and the local authority are very happy, and I'm sure my learned friends on the other side are too, if there are any additional points. We're conscious we've taken this at quite a pace, immediately after half-term, in a day and a half, with many pressures and with many papers arriving your way in the last 24 hours. If there are additional questions which would be assisted by a note in writing, we're happy to do that.
But personally, I think the argument has been very high quality, Ms. Gallagher. And I'm assuming Ms. Markham doesn't want to add anything in reply.
Well, my Lord, there were one or two matters. May we deal with them very briefly in writing?
One
Noting
page.
the time now. Grateful, my Lord.
Tomorrow morning, 10:30.
Thank you.
Good. We will take time to consider our judgments, and when we hand them down, you will make sure you comply with the General Council of Wales provisions as to the embargo. You will use them for the purpose of agreeing the order only and agreeing any consequential directions, and if you can't agree them, we'll deal with those in writing. But I do want to reiterate that the argument has been of high quality, and the decision we have to reach is obviously extremely difficult, and everybody in court or watching on the live stream should be aware of the anxious consideration the court will give to